Imagine you're walking down a city sidewalk on a bright afternoon when you notice two police officers detaining someone near a storefront. A small crowd starts to gather. You pull out your phone because you want a record of what happens next. One officer sees you and says, "Put that away, you can't film us." In that moment, most people don't ask a legal question. They ask a survival question. Can I keep recording or am I about to get arrested? And that's exactly why this topic matters. Because the short answer is not a simple yes or no. In many situations across the United States, recording police in public is generally protected. But that protection is not unlimited, and the details can change fast depending on where you are, what you record, whether audio is involved, whether you're the person being stopped, and whether police can honestly say you are interfering. By the end of this video, you'll understand the general rule, the biggest exceptions, the mistakes that get people into trouble, and how to think clearly if this ever happens in real life. The first thing to understand is that this issue is really about two different ideas that people often blend together. One idea is transparency. In a free society, people usually have the right to observe and document what public officials do in public spaces. The other idea is control. Police officers are allowed to secure scenes, manage safety risks, and give lawful commands when they are doing their jobs. Most of the real conflict happens in the space between those two ideas. So, is it legal to record police in public? As a general rule, yes, in many circumstances it is. Federal appeals courts in multiple parts of the country have recognized a First Amendment right to record police and other government officials performing their duties in public. Courts have said that gathering information about what public officials do on public property is part of the freedom protected by the First Amendment. The Department of Justice has also taken the position that people have a constitutional right to record officers carrying out their duties in public, and that this kind of recording helps accountability and public confidence. Reporters Committee for Freedom of the Press Justice. Gov. That sounds strong, and it is. But here's where many people get confused. A protected right is not the same thing as an unlimited right. Courts have repeatedly said that recording police can still be subject to reasonable time, place, and manner restrictions. In plain English, that means the government may still impose certain limits if those limits are tied to legitimate concerns like safety, scene control, or preventing interference, rather than simply silencing criticism or hiding what officers are doing. Media. CA11. U.S. Courts. Gov Justice. Gov. That phrase, interference, is where things get messy. People hear it all the time, but they don't always know what it means. Recording by itself is generally not interference. Standing at a reasonable distance, holding up your phone, and documenting an arrest on a sidewalk is not the same thing as physically blocking officers, crowding into a crime scene, refusing to move from a danger zone, or repeatedly stepping into the middle of a police action. The Department of Justice has said that merely criticizing police, even harshly, does not by itself count as interference. That matters because sometimes the real reason an officer wants recording to stop is not safety. Sometimes it is discomfort, anger, or embarrassment. Legally, that is not supposed to be enough. Justice. Gov. Suppose you're on a sidewalk and an officer tells everyone to move back behind a line. Does your right to record disappear? Not necessarily. In many cases, you may still be able to record, just from farther away. The key question often becomes whether the order is a genuine safety or operational measure, or whether it is being used as a pretext to shut down observation altogether. The Reporters Committee notes that restrictions must be tied to substantial interests and still leave open some opportunity to gather information. So the issue is often not, can you record at all? But from where and under what conditions? Reporters Committee for Freedom of the Press. And that leads to another point people miss. Public means public, but not every place that feels public is legally the same. A city sidewalk or public street is not the same as a private business, a hospital hallway, a secured government building, the inside of a school, or a restricted area behind police tape. If you are on private property, the property owner can usually tell you to leave. If you refuse, the issue may stop being about recording and start becoming trespassing. Even on property connected to the government, different access rules can apply depending on the kind of place it is and what function it serves. So when people say, it's public, I can record anything, that is too simple. Now let's talk about the part that surprises a lot of people. Video and audio are not always treated exactly the same way. Silent video of police in public is usually the easiest case to defend legally. Audio can be more complicated. Why? Because recording sound can trigger state and federal eavesdropping or wiretapping laws, especially when the conversation being recorded is considered private. Federal law generally follows a one-party consent rule, but states can create stricter rules, and the legal question often turns on whether the people being recorded had a reasonable expectation of privacy. In a loud public street encounter, privacy arguments are usually weaker. In a private office, home, or closed room, they can be much stronger. Reporters. Committee for Freedom of the Press. This is one of the biggest reasons people should be careful with blanket statements online. You'll hear someone say, recording police is always legal. Then someone else says, no, it's illegal because of wiretap laws. Both statements leave out important context. If an officer is doing official business in public view, courts have increasingly recognized protection for recording that activity, including audio in many situations. But if you secretly capture a conversation in a context where privacy expectations are higher, especially in a state with stricter consent rules, the analysis can change. So if you want the safest broad takeaway, it's this. Openly recording police activity in public is usually on stronger legal ground than secretly recording conversations in places where privacy may reasonably exist. Reporters Committee for Freedom of the Press. Reporters Committee for Freedom of the Press. Let's make that real with a hypothetical. Imagine you are standing 20 feet away from officers arresting someone in a parking lot outside a grocery store. You hold your phone in plain view and record what you can see and hear. That is very different from hiding a recorder inside your jacket and trying to capture a private conversation inside a back office at a police station or inside someone's home. Same phone, same person, totally different legal setting. There's another detail that often gets overlooked. Who is doing the recording can matter. A bystander on a sidewalk is not always in the same legal position as the driver or passenger in a car during a traffic stop. Courts have recognized that traffic stops are unusually tense and potentially dangerous situations. That doesn't mean police get a free pass to ban recording. In fact, the Fourth Circuit held in 2023 that live streaming a police traffic stop is protected by the First Amendment. But the court also showed how these cases can get more complicated when the person recording is actually part of the stop and officers claim immediate safety concerns. United States Court of Appeals for the Fourth Circuit. That case is a good example of why legal rights and street reality are not always identical. A court may eventually say a policy was unconstitutional, yet an officer might still avoid personal liability because the law was not clearly established in that precise situation at that moment. That is frustrating, but it explains why people sometimes hear about a court recognizing a right and still see no quick consequence for the officer involved. So when you ask, can I record? There are really two questions hiding inside that one. Is the conduct constitutionally protected in general? And if a conflict happens anyway, how clearly settled is that rule in the specific jurisdiction and situation? Now let's deal with a common myth. Some people believe police can automatically stop you from recording if they simply don't consent. That is not how this works in public. Officers do not get a personal privacy veto over recording merely because they dislike being filmed while doing public duties in a public place. Courts and legal advocacy groups have repeatedly framed recording public officials in public as part of public oversight and information gathering. So if an officer says, "You need my permission," that statement is often legally shaky in a standard public space encounter. Reporters Committee for Freedom of the Press Justice, Gov. But here's the catch. Even if the officer is wrong, the street is usually the worst place to try to win an argument. That doesn't mean surrender your rights. It means think tactically. If an officer orders you to move back a reasonable distance, ask calmly, "Where would you like me to stand so I can comply and still observe?" If the officer says you are interfering, ask, "Am I free to record from over there?" If the officer demands your phone, do not physically resist, but you can clearly say, "I do not consent to any search or deletion." Those words may matter later, even if they do not change what happens in that moment. And that brings us to your phone itself. Can police take it? Can they search it? Can they delete your video? The safest answer is to separate those questions. Police may sometimes physically seize a phone, especially in arrest situations, or if they claim immediate evidentiary concerns. But searching the digital contents is a different matter. In Riley v. California, the Supreme Court said, police generally must get a warrant before searching digital information on a cell phone seized from an arrested person. The Department of Justice has also said officers should not destroy devices or delete recordings under any circumstances, and generally should not search or seize recording devices without a warrant except in limited situations. Legal Information Institute, LII Justice. Gov. That is a powerful point, because many people assume the moment police get hold of a phone, everything on it is fair game. That is not the general rule. The government may have authority to secure a device in some circumstances, but that does not automatically give officers a free right to start scrolling through your photos, texts, and videos on the spot. And deleting a recording is even harder to justify. From a constitutional perspective, deletion is not just interference with your property. It can destroy evidence and silence protected documentation at the same time. What about live streaming? That adds another layer. A normal recording stays on your phone unless you upload it. A live stream sends the scene out in real time. Some courts and commentators have noted that officers may argue live streaming creates special safety risks because someone watching remotely could react in real time. The Fourth Circuit recognized live streaming as protected speech, but the case also shows how governments may try to justify restrictions based on officer safety. So live streaming may be protected, but it can attract more aggressive pushback than ordinary recording. United States Court of Appeals for the Fourth Circuit, EFF.org. Here's a practical question people rarely ask until it happens. What if you are not filming police directly, but an officer just happens to walk into your shot? That usually does not create some new legal problem by itself. In public, people, including officers, are often incidentally captured in photos and videos. The legal concern usually grows when you intentionally refuse lawful scene management commands, enter restricted areas, or record in a context where privacy interests are stronger. Now, let's turn to protests, because this is where recording rights get tested the hardest. During demonstrations, marches, and crowd control situations, police often establish lines, restricted zones, and dispersal orders. The right to record still matters enormously in those moments, but risk also rises. The Reporters Committee advises people covering tense situations to record from a safe distance if possible, remain open about recording, avoid interfering, and comply with orders while calmly asserting rights when appropriate. The hard truth is that even a person who is legally in the right may still be detained or arrested in a chaotic scene, then forced to sort it out later. Reporters Committee for Freedom of the Press. This is why the smartest legal education is not just about what the law ideally says, it is also about what reduces avoidable risk. If your goal is to document police conduct effectively, your best habits are usually simple. Keep some distance. Keep your hands visible. Don't rush toward the scene. Don't touch officers or suspects. Don't wedge yourself between police and the person they are detaining. Don't scream over commands in a way that makes it look like you're trying to control the scene. And if you are recording on a phone, consider backing up automatically to the cloud if that can be done safely and lawfully. There's another misconception worth clearing up. Some people think the right to record belongs only to journalists. That is not true. Courts and the Justice Department have discussed this right as belonging to ordinary members of the public, not just credentialed media. Your right to gather information about public officials in public is not supposed to depend on whether you work for a news station or have press written on a vest. Justice. Gov Media. CE 11. Use courts. Gov. At the same time, not every officer on the street will know the nuances of First Amendment case law. That is one reason tone matters. A calm person with a phone is often safer than an angry person trying to deliver a courtroom lecture during an arrest scene. That may not be morally satisfying, but it is practically important. You're not waiving your rights by being strategic. You're increasing the chance that your recording survives, and that you do too. So what are the biggest mistakes people make? One is assuming that if something is protected, police can never stop them. That is false. Police may still give lawful orders about distance, movement, and safety. Another is assuming every command is lawful just because it is shouted loudly. That is also false. The fact that an officer says, "Stop recording," does not automatically make that order legal. A third mistake is confusing public interest with public place. Something may be newsworthy and still happen in a location where recording rules are more restrictive. A fourth mistake is forgetting about audio laws. People who would never secretly record a neighbor sometimes secretly record police in ways that create separate consent law questions. And maybe the biggest mistake of all is physically resisting when an officer reaches for the phone. Legally, that moment may feel outrageous. Practically, it can escalate into charges that overshadow the original issue. Imagine one more scenario. Suppose an officer says, "You can't stand here," but you know you are on a public sidewalk. Do you plant your feet and argue constitutional law? Or do you take 2 steps back, keep recording, and say, "I'm complying, I'm just documenting from here"? In many real-world situations, the second approach protects both your safety and your evidence better than the first. There's also a deeper reason this right matters beyond any single encounter. Recording police has become one of the main ways the public learns what actually happened in disputed encounters. Memory is unreliable. Official reports can be incomplete. Witnesses may miss key details. Video is not perfect, but it can reveal timing, tone, distance, commands, force, and context in a way that arguments alone cannot. That is a major reason courts and civil liberties groups have treated this issue seriously. It is not just about curiosity, it is about accountability. But there's one more detail people often overlook. Accountability cuts both ways. A recording can protect civilians, and it can also protect officers falsely accused of misconduct. Good documentation is not anti-police by nature, it is pro-evidence. That distinction matters, especially because this topic gets pulled into political arguments so quickly. A camera does not automatically prove abuse, and it does not automatically justify police either. What it does is preserve facts. So if you want the cleanest practical answer to the question in this video, here it is. In the United States, it is generally legal in many circumstances to record police performing their duties in public. That protection is rooted in the First Amendment and has been recognized by multiple federal appeals courts, but it is not absolute. The biggest legal trouble spots are interference, safety-based restrictions, private property, restricted areas, and audio recording in places where privacy or consent laws may matter. Police generally do not get to ban recording just because they dislike it, but they may be able to impose lawful limits tied to real operational concerns. Reporters. Committee for Freedom of the Press, Justice. Gov. And if police do take your phone, remember the next layer. Seizing a device is not the same as having unlimited authority to search it. Under the Supreme Court's Riley decision, searching digital contents generally requires a warrant. And according to the Department of Justice's guidance, deleting recordings is out of bounds. Legal Information Institute, LII Justice. Gov. If you ever face this in real life, the smartest mindset is not bravado. It is clarity. Know the general rule. Know the limits. Stay calm. Record openly when possible. Keep your distance. Do not interfere. State clearly that you do not consent to any search or deletion. And understand that if the situation turns into a legal fight, the courtroom is where the final answer gets tested, not the side of the road. Because the most dangerous thing in a police encounter is often not ignorance of one rule. It's false confidence in a rule that has exceptions. So the next time you see someone online say, "You can always film police," or "You can never film police," you'll know both claims miss the real picture. The truth is more useful than either slogan. And if you remember nothing else from this video, remember this. In many public situations, the law is on the side of recording. But the safest way to use that right is to understand exactly where it gets stronger, where it gets weaker, and how fast a simple act of documentation can turn into a much more complicated legal moment.